2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hivner. On behalf of Judges Stafford and McBrayer, we welcome you to our virtual courtroom. It will go just like if you were present in the courtroom. We'll hear from each side. The appellant can reserve some time if up to 5 minutes if they wish. If there are no questions or exclamations of any sort, why don't we call the case?
Re Alleigh B.
Is the appellant ready?
Yes, Your Honor.
Okay, you may begin.
This matter is a termination of parental rights case. I represent the appellant and mother, Ashley C. And I'm not going to argue grounds today because based on her own testimony, I think at least one ground has been established. So this is a best interest case. And because it's a best interest case, I'm going to reference Re Alleigh P, which is E 2019-01606-COA-R3-PT, a very recent decision filed June 17th of 2020. And because it is a best interest case and we want to look at the bonded relationship that this parent has with her child, and also look at how the court got some of the other factors wrong. And so the bonded relationship, we have testimony from workers at Blue Monarch, a recovery center, where Miss C was in a treatment program there, and then she moved to a different treatment program. But while in the treatment program there, she had visitation with this child and a sibling of this child. And this was the only opportunity that the sibling and this child had to have any kind of relationship. The petitioners and the custodian of the other child offered testimony in several places in pages 27 and 28 and 32 of the transcript. The petitioner, Mr. Brown, offered testimony that there had been sibling contact, and then the custodian of the other child basically contradicted, or at least did not support, this testimony about sibling contact on page 151, 162, and 170. And the other petitioner, Miss Brown, offered testimony on page 175 that said, yes, we have talked about contact. However, the testimony from the workers at Blue Monarch was that this sibling contact occurred frequently, and Miss C worked to build this sibling relationship and also had a bonded relationship with this child. And that testimony is available on page 232 of the transcript. And well, I've lost reference to the other pages on the transcript, but the workers at Blue Monarch had testified about this relationship, and the mother had testified about the relationship. And on page 10 of the transcript, the judge, in summarizing, said that she found the mother's testimony credible. So that we can accept the mother's testimony as credible because the judge found so. And the visitation that the mother had, because that's one of the grounds is to look at the visitation, has been covered, and she was successful in the visitation. And at some point, the court reduced the amount of visitation, but she kept the visitation because the measure is regular visitation. She kept that visitation such that it was, when circumstances changed, and she was able to do it in a more constrained environment. And so she maintained visitation. The other factors that one would look at is whether she's made an adjustment of circumstances and affect a lasting adjustment. And you look at the testimony from the workers at Blue Monarch that she had went through this treatment program and she went into a subsequent treatment program. And by the time of the hearing, she was living independently and she was an employee of the subsequent treatment program, that she had been so successful with that program that they kept her as a transportation coordinator, and she had established independent living by that time, and that is covered in pages 190, 192, 219 through 220 through 223 and 233 through 234 in the transcript, how she has successfully changed her circumstances. And the reference case, Allison P, is similar. A mother came from bad circumstances and was in a recovery program, and in Allison P, the mother was nowhere near as successful in the recovery program. She was just starting in that recovery program, but the court found that she had a bonded relationship with the children, and therefore the best interest test failed and the termination was overturned. In this case, mother has completed a treatment program. In Allison P, the mother was living in a trailer somewhere in East Tennessee with maybe half a dozen other participants in the treatment program. In this case, the mother's living independently. She has independent income. And when you look at the question of whether or not she's paid support, Lindsay Vanover of the Blue Monarch treatment program offered testimony that while you're in a treatment program and it's a residential treatment program, generally the courts have deferred requiring child support to be paid. And so you look at her support payments that they picked up after she got out of the Blue Monarch program and was making regular income, and the judge actually miscalculated the finding on the child support award, which was $161 per month, and the judge misconstrued it as $161 per week. And I think that wrongfully influenced the judge's decision on whether the parent had supported or not. So this mother has made an adjustment of circumstances, and she's made a lasting adjustment in circumstances. And you had drug court administrator testify to her progress in that program and the recidivism rate in that program, such that there's a likelihood that her change in circumstances will continue into the future. So she has a meaningful relationship. She's maintained visitation. The judge offered an opinion not backed by any counseling, any testimony from any experts, or any fact that a change of caretakers would have an effect on this child. However, the testimony from the Blue Monarch workers is when this child came to visit, the child was bonded with the mother, actually called her mama, and was also bonded with a sibling. This mother is the only opportunity this child has to have a relationship with a sibling, because any other opportunity, the petitioners, it's all hollow talk. They've had this child for several years, and at most there's maybe been 4 contacts with a sibling over that time. The rest of the sibling contacts have been through the mother. And if you look at Adeline S., which is 56 Southwest 3rd, 794, 796, in situations where this meaningful relationship exists and it flows to the parent, then this factor may be given greater weight. And I'm asking you to give it greater weight because even though the court found that there were several children in the petitioner's home that this child had established a relationship with, it's a false equivalency, because these are not natural born siblings of this child. And that's irreplaceable, to have your natural born siblings and to have access to that relationship. And the only way that can happen is through the mother. So I'm asking based upon this and other facts in the testimony that the court overturn this termination based on a finding that it is in the best interest of this child that the mother's rights not be terminated, that she's in the process of restoring her relationship with this child when this action was filed. And due to COVID and other delays, this case has gone on for an extended period of time, and we need to just get back to the continuation of that relationship. And I'll ask if the court has any questions because I've run out of things to say.
I see no questions, so thank you very much. And we'll move on to will this be a split argument? I see
Yes,
both.
Your Honor. This is Mr. Kirkpatrick. I'll take 10 minutes and Mr. Bailey will take 5.
All right. Mr. Kirkpatrick, you may begin.
Yes, Your Honor. What Mr. Trickey failed to mention to the court, which was, I think, central to the judge's decision, and was the fact that when the mother was at Blue Monarch, she violated the rules of that establishment. And what's troubling about it is not the event itself, but the fact that she admitted that she knew when she violated by reaching out to some boyfriend or something. She knew when she did that she was jeopardizing her status in that program and her relationship with the child, and obviously placed her communication with this boyfriend at with greater emphasis than her relationship with this child. And she got kicked out of Blue Monarch, which I submit distinguishes this case from Re Alleigh B. In that case, the court noted, and the court said it was a very close case, and the court struggled with it on the issue of best interest. But in that case, the mother was in complete compliance. In this case, the mother, again, was kicked out of Blue Monarch with full knowledge and initially even lied to him about it. And furthermore, Your Honor, the mother, and the court, I'm sure, is familiar with the fact that the mother in December of 2016 was taking the child to multiple meth houses with the child in the van, doing meth intravenously in the presence of the child, stayed up all night going to these meth houses. And she testified that despite that, she considered that she was taking good care of the child, which to me begs the question as to what her ability to take care of this child, if God forbid she ever got custody of this child, if that's her standard of parenting, that she considered she was taking good care of the child, which quite frankly is contrary to the evidence in the case concerning the condition of the child when the police found the child and so forth. So her statement that she was taking good care of the child weighs greatly against her. Your Honor, this relationship with the child that she supposedly has, it is true that when she was at Blue Monarch, she was advancing until she got kicked out. She actually had, I think, every other weekend. Well, by virtue of that, in her knowing violation, that she knew she was sacrificing the child, and this case was pending during all this, her visitation went from every other weekend to 3 hours a week, basically supervised. That's what she did in terms of her meaningful attempts to have a relationship with this child. Your Honor, and I believe, I know the court has to still make a finding on this severe abuse. I mean, obviously she admitted she used drugs during the pregnancy, and her boyfriend at the time admitted that they both did it during the pregnancy. That's just undeniable, and that's certainly a grounds for severe abuse. But I also submit that her conduct in December falls under the section for the definition of severe abuse. So I believe that's solid on the child support. I think what the court did was, the proof doesn't obviously bear that out. The court mistakenly in her decision converted the monthly figures to weekly figures, the same proportion, same principle. But there was a child support order in January of $161. So they were well aware of her situation. She was working at the time, had income at Blue Monarch, and she was ordered January to pay $161. Well, she only paid $50. The court considered that to be token, whatever. I don't think that's the strongest issue about the child support. But one of the factors, of course, of best interest is whether the mother consistently pays in accordance with the guidelines. It doesn't have to do with willfulness. Just did she pay child support in accordance with the guidelines? Well, for the longest time, for over a year, she only paid $50 a month instead of 161. But it's our position, Your Honor, that this child came into, when the child came to the care of the Browns, I'll refer to them as the Browns, the petitioner grandparents, came into their custody. The child was 2.5 months old when those events in December occurred with the meth, using the meth in the van for 5 days and so forth. And has been in their care ever since. Child's 4 years old. And the court noted this. This is the only home that this child's ever known. And the child to which he refers, Brody, her older brother, there's a pending case that's still pending in regard to that child with the maternal. Her own parents are petitioning to terminate that child. It's my position. I think our position that the mother who wants us to have blind faith that when she finally, sooner or later, she's going to get out of this environment of being in treatment. She's going to obviously be out on her own, which we've not been able to see how she performs. She's been in drug court before. It's a 2-year program. That didn't last long. Just a short time thereafter, she's using meth in a van and going to meth houses. So obviously that didn't take. She's been on probation at least 3 different times on 3 different offenses, violated each one despite her promises she was going to comply and do better this time. And each sequential time she violated her probation. So she wants us to believe that now when she gets out and takes up with some man, because that's apparently her priority, that she's going to stay sober this time. And even I believe and I don't know how close I am in time, but I got 3 minutes left. Is that it? Okay. This Lindsay Vanover at Blue Monarch, and by the way, when I asked her about, there was testimony she was trying to suggest that she was doing pretty good at Blue Monarch and all that. When I asked her, with her getting kicked out, was that a sign of progress? And she said, no, I have to admit, no, it's not a sign of progress. But this Jeannie Driver, who also had worked at Blue Monarch, conceded that in a treatment center, you're somewhat in a bubble. So there's no way to project whether or not you're going to stay sober when you get out. And it's true that she's now working at Coffee County Drug Court, but she's still staying in one of their places and she's under their auspices. So she's still not completely independent in the sense that she's out on her own. The Browns are, I think it's undeniable, are fit and proper persons to adopt the child. I don't think that's an issue. Just looking at my notes, Your Honor. And there's an interesting proposition I made regarding, and this has to do with grounds, but I submitted that the wanton disregard was also relevant because prior to incarceration, because this conduct in December was certainly a wanton disregard for the welfare of the child. And she went into jail at that time. She got out, but she was under court-ordered supervision in a treatment center. So I submit that falls within the interpretation of that statute. So I think that's probably another grounds. But nonetheless, Your Honor, I think that overall this case is distinguishable from that Re Allison case. This child has been, like I said, this is the only home this child's ever known. The mother has sacrificed her relationship with this child by her conduct while this case was pending. Mike Lewis, who's the head of drug court. When I asked, because you'll see in his brief, Mr. Trinke argues that, that program has a great recidivism rate. Well, that's a misinterpretation of his testimony. He says that they try to track them for 5 years to see if they ever had a criminal conviction. When I ask, can you project whether she'll stay sober or not? He says, I can't project that at all. So there's no assurance whatsoever that she's going to stay sober. And if history, and we don't, the only guide that we have is her prior conduct. And like I said, she's already been through drug treatment. It's a 2-year program, and that didn't last. So, she's asking us to give blind faith that this time is going to be different, and to start thrusting that child into her care. And I believe the court was correct. You don't have to have expert testimony. It's common sense tells you that this child has been in this home for 4 years, and they have 2 children of similar age. It's virtually like siblings. And anyway, I guess I'm about out of time, so I'll yield to Mr. Bailey.
Thank you, Mr. Kirkpatrick. Mr. Bailey?
Your Honors, if it may please the court, Matt Bailey of, I guess, the Van Buren County Bar, a little bit all over. In this case, there are grounds, and I believe the best interest favors the termination. As far as grounds are concerned, severe abuse. The mother said that she weaned off of drugs after she found out she was pregnant, which implies that she used drugs after knowing she was pregnant. She also testified that she didn't know that she was pregnant for around 6 months. I don't find that very believable. So I'd say that the severe abuse ground was proven. Failure to provide support ground, I argued in my brief, I didn't think it was proven, but that's my opinion as guardian ad litem. The court is the trier of fact, not the guardian ad litem. And so that ground may also be proven, Your Honors, even if personally I don't know if it was. Regardless, since we do have a ground of at least severe abuse, I think what I see in the best interest, Your Honor, and what distinguishes this from Allison P. and what distinguishes it from the Wesley case that I referred in my brief is the age of the child. The children in the Wesley case and in this Allison P. case are quite young, 5 or 6 years old. Nonetheless, there is a difference between a 5 and 6 year old that knows a mother as his or her mother, and a young baby that knows no one but the petitioners is her mother and father. At least in my mind, that is a very key difference between Allison P. and Wesley. In addition to that, perhaps a little less important, but also very important, is that obviously mistreating any child is very heinous. Nonetheless, when we have a tiny baby in 18-degree weather with no heat, no clothes on in 18-degree weather, a swelled up diaper, skin stuck together under her neck and her arms, almost glued together, clabbered milk, dirt and debris in the bottle. Obviously, any mistreatment of any child is heinous, but it is especially heinous when something doesn't kick into a parent that child needs to be protected. So that is a key fact to me. The age of the child, the condition she's in, and then I think I agree complete with the chancellor. It bothers me. This was a case where it was probably leaning the mother. When she got kicked out of Blue Monarch, while in isolation, that is not a big incident. The fact that she, even after getting treatment and counseling and all that in Blue Monarch, there's still something that is compelling within her to have to reach out to these bad men, for lack of a better word, even when she knows it could get her kicked out, even when she knows this TPR is pending. I think it's a pattern, and it's a very troublesome pattern. In this case, the father of the child, I think the mother was found with swelling of a lip and then beaten her, just, violent men on drugs. And I think that is very troubling, knowing that a TPR is hanging over her, knowing that she needs this, that she nonetheless reached out to that former boyfriend. So in my mind, while there are other factors Those are the key things: the age of the child, the horrid conditions the child was in. Unlike the Allison case where the mother had been in, I think, 5 months and was doing well, in this case, we also have the mother getting kicked out of a program. For those reasons, Your Honor, I would ask that this court affirm the termination of parental rights. Thank you.
Thank you, Mr. Bailey. Mr. Trenchy.
Yes, several things need to be corrected. This was not a boyfriend or former boyfriend that she contacted. It was an individual she had met briefly, and her contact was to have closure with this individual, and the need for that closure had flowed from what she had gathered in her treatment. And you look at her testimony, she had been in communication with her counselor about this. Yes, she acted inappropriately. She'll admit she acted inappropriately, but she had graduated from the Blue Monarch program, and she was in a transition phase where she could transition to their independent housing. And that's when they asked her to leave, because they had zero tolerance on these rules. Now, if she'd waited another week and she'd been in a housing, the restrictions on use of media and use of outside contact would have been lifted. And she went straight from there to another program that provided her a support environment, and she completed the requirements in that program and gained independent housing. The housing is arranged at auspices of the drug court program. However, once you're paying for it and you're renting it, you're there for month to month, and you are independent of that program in terms of maintaining that housing. So she was out from under that shelter. She was out from under that bubble. And if you look later on, Jeannie Driver did say, yes, that was a setback. But then Jeannie Driver also said, as Blue Monarch counselor, that her response to that setback was a significant indicator that she had made progress in treatment, that she didn't go all to pieces, even though that was a serious setback. And when you talk about this child, and Mr. Bailey raised all the horrible pictures to the jury that you could, when the police found this child, she was in the care of her father. The mother had previously been thrown out of a moving van by the father, so we can't hold the mother responsible for the condition that child was in at that point. The mother's testimony was the last point she saw the child, the van had heat, the child had food, the child had clothing. What happened after that under the father's care is a whole different question, but we can't pin that on the mother. And if you look at page 78, 79 of the mother's testimony, when it is the very court that heard this termination constrained her contact to this limited amount and said, let that stand until we have the hearing. So at that point, no matter what she did, she was in a position where she could no longer address improving that contact. And that was up to the court. And when they ratcheted that down, and then it's later disingenuous to say, oh, well, she didn't have all this additional contact she started for. And finally, we need to wanton disregard, because in any charges that she was held for occurred prior to the birth of this child. Thank you, Your Honors.
Thanks to all three of you. Mr. Hivner, would you please recess court?
This honorable court is now adjourned until tomorrow.